Okay, so this is an official welcome to all of our guests, online and offline. So if you are watching online, there are a couple of points. If you could just give me a quick comment in the chat, because I am monitoring the chat as well. If you could let us know that you can hear us and that you can see us, that'll be great. Anyone can just put a comment in on the chat. Someone says we missed the earlier comments. I promise you, you did not miss much. And then one quick point to the online guests, if you could please place your questions in the Q&A box. It's kind of weird speaking to a live audience and talking to you about a Q&A box. But for the online guests, if you could please put your questions into the Q&A box. It's very difficult to monitor both the chat box and the Q&A box. So if you could please put your questions into the Q&A box, I will make sure that we incorporate as many of the questions as possible into tonight's conversation. And I think that's as far as we will go on the housekeeping for tonight. On that note, let's get right into it. Super exciting evening for us today. We are experiencing, like I said, a hybrid conversation, a hybrid event, the first of its kind here at LexisNexis. This one is special beyond that because we have with us a very esteemed guest. And I'm personally very excited to get into this dialogue. So we're going to be talking about trial advocacy, and this is a thought leadership conversation. As a quick intro, I'm a random person that decided to facilitate this event. I happen to lead a company that works in very close partnership with LexisNexis. We are almost one and the same, but not quite. And in terms of today's session, we are very, very, very pleased and honored to have with us today, this evening, not just a guest of LexisNexis and very much a fabric of the LexisNexis brand. We have an author, a former judge, and someone who is incredibly respected in our society. We have senior counsel advocate Ismail Hussain, a former judge of the High Court and the Competition Appeal Court. Advocate Hussain was a member of the Independent Electoral Commission from 1994 to 2004 and has served on various legal training panels, including the panel of trainers for Law Society and Legal Aid South Africa. He currently provides training in drafting, trial technique, commercial drafting, and financial compliance courses attended by attorneys, advocates, and businesses. Advocate Ismail has provided training services to 13 government departments. He is also the author of the LexisNexis title Practical Drafting Skills, a guide to e-discovery in South Africa, and his newest edition, Trial Advocacy. Advocate Hussain, welcome and thank you for joining us. Absolutely. Do you want to just check if you want? Okay, I can. Yes, there we go.
All right. I think it's working now.
Okay, great.
Right.
All right, so let's get straight into the conversation. Let's start with you just giving us a brief introduction into your journey so far and how you arrived to this day.
Well, I'm a bit disappointed that you mentioned that I trained 13 government departments. Apparently, they were not listening. Well, fact is, I've been in the profession for 41 years, and that's a long time. It's almost as long as I've been married, and that's also a big, quite an achievement, I think. To the same woman, by the way. I think most of what I've been doing has been dealt with, and my purpose here is not to talk about the legal profession generally, but to talk about litigation. And it's a profession that doesn't adapt to change very easily. You know, we're generally a bunch of fuddy-duddies, you know, gray men with gray hair, you know, that's what we are. But things are changing quite rapidly now. And there are two things that I want to mention that's bringing about change within litigation. And the two are interrelated, although many colleagues don't realize that they're interrelated. The two are, the one is contingency-based litigation, and the other is case management. Now, the problem with litigation, I mean, most of you here know, if you're involved in a case, it takes too long and it costs too much money. And who are the culprits? Who causes this? It's the attorneys and the advocates. They make it too complex. They make it unpredictable. And we know that attorneys engage each other in all kinds of complex procedural disputes. And they forget about the substance of the dispute. Now I mentioned contingency litigation on the one hand and case management. And I'll tell you where the two meet. Contingency litigation is not anything new. It's been around for decades, except that the Law Society pretended that it didn't happen. And they didn't approve of it. But that has changed. So now clients walk into an attorney's office and say, I want you to take this case, but you get paid when the judgment, firstly, you must succeed, and then secondly, the judgment must be satisfied. So what's happened now, and this is a massive change for attorneys and advocates, and that is all the risk in the litigation is now passed on to the practitioner. Now, that is why I wrote this book. It's because there's now an imperative for practitioners to succeed in court. Can you imagine if they don't succeed, they don't get paid? Now, that's been the case in the United States, for example, in Canada, for many decades. That is why most of you know that the Americans are highly litigious people. It's because they can go to an attorney and say, take on this case, you get paid if you win. So now, can you imagine if an attorney takes on a case on a contingency and it takes 3 to 6 years to finalize? They'll be insolvent. They'll have to fund it for 3 to 6 years and get nothing back. And then worse, if they lose the case, it's a complete loss. Okay, so it's a risky business. So what do they need to do? They need to practice the art of litigation correctly. From the moment they take instructions to the point when they argue the case finally before a judge, that needs to be, that requires an enormous amount of skill, because now you have to win. In the past, we got paid for losing cases. I mean, it was brilliant. When I was a young practitioner, we didn't have contingency litigation. And we took on a case, we lost it, and client then got billed. So there's a big change in that. So now let me move to the next big development. Here it is fairly recent, but the case management started in the United Kingdom in 1990 already with the Wolf Commission. Lord Wolf is an English judge, and he was commissioned to conduct an inquiry into civil procedure in England, because they were taking 3 to 6 years as well, and it became unaffordable. So, you know, a system that resolves dispute for people for citizens of the country, if it becomes something that only the wealthy can afford, then it doesn't serve its purpose. People will start taking the law into their own hands, as they do in this country. Your tenant doesn't want to move out. What do? You don't issue a summons. You get someone who looks like Mike Scooter and you send him along, and the tenant is out. So if litigation can become more predictable, more focused on the substance of the dispute, and cheaper, that's what we want. Now, that was the recommendation of the Wolf Commission, which has been adopted here in this country. But we have a rules board that's not particularly functional. I hope somebody's listening. So, they've fallen way behind. Our rules are not too relevant at the moment. So the judges have taken this, an active role, and they've created what we call practice directives. And now they take an active role in managing the case. And that's broadly known as case management. But what the judges are actually doing, they're not managing the case, they're managing the lawyers. They're getting the lawyers to be more focused, to stop taking silly technical points against each other and running up costs and wasting time. And it works. Now, I'll give you an idea of how effective case management is. In Canada, they can finish any case in the High Court from the point of issuing a summons to finality through a judgment or a settlement. 3 months. Can you believe it? 3 months. And I had discussions with the master of case management in Montreal, and they have absolutely tight control over the profession. There's no time wasting, there's no postponements. Everybody's ready when they come to court. And no one, I mean, here, ask anyone, they'll tell you what happens on day one of a trial. It gets postponed, okay? Or it gets struck off the road, okay? Why? Because the lawyers were not ready. So what I've done with this book is I've taken every aspect of dispute resolution from the point of taking instructions, from the point when a client walks into a practice, all the way to finality. I've provided instructions in the form of a handbook. This is really a handbook. It's not an academic writing. It tells the lawyers what to do. But more importantly, it tells lawyers how to win. And that's what the lawyer wants to read. But they don't want to read something some jurist said in the 12 tables. Or it's all irrelevant now. So that's what the book is about.
Fantastic.
Yeah.
So you've escorted us nicely into the discussion about the book, which is fantastic. Just so everyone is aware, you are joined here tonight by 81 colleagues online. So this is actually a very well attended event.
Yeah.
I just thought I'd give my online fellows a shout out. All right, so let's get right back into the conversation that we're having here. I see that one of the things that your book promises is trial technique from a judge's perspective.
Yes.
Now, you did comment about how judges have changed their role in the courtroom, but if you could just double click into that judge's perspective.
Yeah. Look, it must be obvious to most of you that when I researched this book, I read a lot of books on trial advocacy, mostly written in England, Canada, United States, Australia, New Zealand. I read the lot. And this book is unique in one sense. What it does is, at every phase of the trial, before I go into good technique, I start talking about what the judge is looking for. What does the judge want? How do you convince the judge to accept your version of what happened? Because there are disputes. There are different versions before the judge. Now the judge, they were not there. They need to work this out from the evidence that is presented. Now, if the evidence is bad, the judge can't give a good judgment. So you're not of any assistance. So this is about what is the judge looking for and how can you assist the judge? So that's the first part of every section of this book. And then it moves into, now let's see what you do. Firstly, when you're preparing. Now remember, what happens in court is a performance skill. You have to get on your feet and you have to perform in public. And that's not easy for most people. That is why you get some lawyers who never enter a courtroom. They are what we call chamber lawyers. They stay in their offices, they write contracts, they do wills and estates and conveyancing, they do company mergers and so on. it is not easy for someone to stand up in public and perform, especially in front of a very critical audience. You've got a judge who is super critical. You've got your opponent who wants to take you apart. And you've got a gallery who basically don't know what's happening, but have the most opinions. So, the performance skill, we take it from the minutest detail. How do you prepare to present evidence in court? But this book is also unique in the sense that it's the only book on trial advocacy I know that starts with a presentation on voice and accent and articulation. Now, I don't have the skills to write that. I asked an expert to write that, and she's here. I'm very grateful for her. It's Carrie Gosling, and she's a voice expert, and she wrote the first chapter of this book. Now, the point is, how do you persuade a judge who can either not hear you or is struggling with your accent? You know, many years ago, we had an advocate who came from Scotland. He was practicing here in Johannesburg. This was during apartheid, when most of the judges were Afrikaans. And he arrived with a very thick Scottish accent. And they found him impossible to understand. It's as if he needed an interpreter in court. But he was speaking English. So we still have that problem because we're a multicultural, multilingual society. And this book helps you with your voice. And then it deals with, what do you do when you get up on your feet in court? And we start with opening statement and take it all the way through to argument. But the book is comprehensive. It doesn't only deal with trials. It deals with what lawyers do every day, and that's motion court. It deals with unopposed motions. Now, you know, if you go and sit in the unopposed motion court, it's the most boring thing you'll come across. An advocate stands up, he says 3 or 4 words to the judge, and the judge says, okay, A, B, and C of the order. He says, as the court pleases, and sits down. And you wonder, do we have to pay this out to do that? So, well, it's because all the work was done outside court. A lot of work went into it. Now, like any performance skill, if you talk to someone who's in the performing arts, someone who is an actor or a singer or a musician, they spend hours and hours of practicing before they get onto a stage. Now, you know, just because you've got an LLB and had breakfast, that doesn't make you a lawyer. It requires intense preparation. But there's a technique in preparation as well. You could waste your time with all kinds of irrelevant nonsense and still end up being unprepared in court. This book tells you how to be focused, what to focus on. And then you're on your feet. And now we tell you, how do you address the judge? How do you deal with it? I don't think there is a book that contains a chapter on how to handle a difficult judge. I wrote a chapter on that. I started off the chapter by saying, I write this chapter with the greatest of respect. So, and then I proceed to tell the reader how to manage a difficult judge. And then that's part of trial advocacy. Okay, so it's really a comprehensive book. And what I can assure the readers, you know, if you're a practicing lawyer, I promise you, you'll see yourself in every page. You'll read a page and you'll think, oh my God, I did that. And now I know it's wrong. But also tell them how to cure it. How do you fix it? So that's what this is.
Fantastic. All right, so we're getting some nice comments coming through on the chat online. They are nice, I promise. I will pick up 1 or 2 every now and then. So there are some comments about procuring the book, people wanting to know how they can get their hands on the book. So we will definitely be sharing that on the chat. Pam, if you could put some information up on the chat to make sure that everyone knows how they can grab a copy of this book.
Mhm.
Moving along, let's talk about, let's make it a bit funny.
Mhm.
I'm told that you are, you're a very entertaining character when you really get into it. So can you tell us about any real life examples that you've run into in court that's worth
Look,
relaying?
I don't think you'll find any lawyer who has spent more than 10 years in court who doesn't have a few funny stories. But I want to make mine a bit more relevant. One of the things I did in this book is to convince the reader that judges are humans. They're not robots. Your job is to convince them. You have to communicate with them. You can't be boring in court. If you are sleep-inducing, the judge stops listening. And the fact is, judges do stop listening. Okay? Ask my wife, I don't listen to her. Well, I'm sure most of you men were told at breakfast you don't listen well. That can happen with judges. But I can recall a case. I was a young junior and I appeared in the Spring Circuit Court out in the East Rand. And it was in summer, it was very hot. You know what Benoni hot is like? It's that hot. So after lunch, and I promise you the worst time in a trial is after lunch. So I always advise lawyers when they're on trial to eat a very light lunch, just nibble on a salad, no more. If you have a big lunch, you're in trouble, okay? Well, we were hearing this case and you can predict the air conditioning wasn't working. And this was about 30 years ago and the air conditioning still doesn't work. In fact, it's even worse now. So one of my colleagues who was in my own group, who had a dreadful monotone, and he was cross-examining a witness in this boring monotone of his, and he was droning on and on. And I looked up and I noticed that the judge was fast asleep. The judge was sitting with two assessors, both of whom were fast asleep. So I tugged my colleague's gown and I said, look. So he looked at them and he just carried on, just droning. So I picked up, I had a book, so I took it and I dropped it loudly to wake the judge up. But that happens. It can actually happen. So one of the techniques for a trial lawyer is to be able to hold the judge's attention, not just with his content, but with his delivery and his performance on his feet. And that's what I've got in here. You've all heard that there are types of questions you should ask and not ask. Now, most of us were told when you're leading a witness, don't ask a leading question. You learned that at university. But how do you do that? How do you avoid it? I show you how, by using case studies. There are case studies in the book. And I say, let me show you how you formulate a question to bring out this answer. And that's really what an advocate or an attorney does. Remember, we don't use juries in this country, thank heavens. The people who are going to hear your case, the judge is a trained lawyer. So they are looking at it very technically. So you can be extremely fluent and articulate and elegant, but they will see that you're actually talking rubbish. So it doesn't work. You need to make sense and you need to be eloquent. The two cannot be separated. And that's the technique that you'll find in this book.
Fantastic. Thank you for that. So we have a message here from Sunita. She says, got my copy, beautifully written, easy to read and understand, can really hear the honesty and heart in this book.
Okay, good.
So that's a very validating comment coming through. Yeah. Herman Stain online wants to know, could you please indicate where the book is available? and what the price is. Thank you. So there's also another question about the title. So I'm going to read out the title. We have a copy. You should be able to see it on camera. It's called Trial Advocacy, the Art of Persuasion. And then, of course, Pam has put up a link in the chat box, giving you guidance on how to procure the book. All right. So that's some of the stuff coming through. And now I have a question from Terry. I promise you, in-house audience, you will have your time. Okay, you will have your time shortly. So we have a question here. I worked with a judge in the UK who is a great advocate of e-discovery. And on the subject of case management, he told me that he feels more like he is running a business than a case. Do you think that our judges can get to that point?
Yes, I think they can. The problem that our judges have is that I don't think they are properly resourced. The judges in the UK, in the United States, the Canadian judges, the Australian judges are very well resourced. So they have the assistance. A judge should not be bogged down by administration. A judge should not have to walk into court and something is not working, or come to his chambers and find that the internet is down. I mean, if you're in government, you walk in and the internet is working, you go, wow, how did this happen? So we need to fix that as to start with. But the skill sets are there. You just have to show the way. There are judges that are currently sitting who are excellent case managers, but there are also those who haven't got a clue. So we have a long way to go, but we can get there. You see, this judge says it was like running a business. Just give you an example of what they do in England. One of the things we do as lawyers, we discover all the documents. Now, South African lawyers are great at discovering every piece of paper they can find in the office. Okay, so they give the judge a bundle of 300 pages. Actually, 2 pages are relevant to the case. Okay. So what they do in England, the judge, the case managing judge, gets together with the lawyers and says, okay, guys, I don't really know how much documents you've got, but let's set a budget. You are only going to spend so many pounds on discovery. And if you need more pounds than that, you'll have to make an application. And now that gets the lawyers to be more proportionate. So there's narrower discovery. And there was a directive that went out today, in fact. My colleague Nick T over there sent it to me very kindly, that there's a pilot program coming up from the Chief Justice's office, where all filing in our courts will happen electronically. And they already started saying, only prepare bundles of documents that are strictly necessary. Hopefully we can get that going. It will save a lot of time and money. For us, it's a question of getting the contract through without some skullduggery happening on the side. So, okay.
All right. Okay, so that's great. Now I have another comment here, or question rather, from Malasela online. In terms of voice, which you mentioned earlier, would advocate give his opinion on where the level of English plays a role in how a judge may perceive while on the other side during session?
Well, it's a language question. The language in our courts is English. Most of our cases are done in English. You will see there were some recent discussions when Judge Meyer, the president of the SCA, wrote a judgment in Xhosa. One of the judges, I think it was Van der Westhuizen, in the Constitutional Court, over a language dispute, wrote the judgment in 2 languages, which were in dispute. So the judges are alive to this. But remember, language is for one purpose only: effective communication. Now, if you cannot communicate to the judge in the language that is preferred in that court, you'll have a problem. Most of us know that it is not easy to present your case through an interpreter. And I tell you, 80% of the cases here in this country, when you're leading evidence, you have to use an interpreter. I wrote a whole chapter on interpreters in this book, how to deal with them, how the technique that you use when you lead witnesses through an interpreter. So interpreters are very much a part of our lives, and it's going to be that way for the foreseeable future. So it's choice of language, whatever the language is, it's up to you as the lawyer to be really good at it. Now, here's the good news. What we want is plain language. You've heard some lawyers who are seriously bombastic. They use words that even they don't understand. They sound wonderful in court, but only to the audience, because they don't know what's happening anyway. They just think it's like on TV. No one understands it. So, but the point is, if the judge is not understanding you, you're going to lose.
Very, very good advice. Malesela, I hope that answers your question. Now, you mentioned here that there's some aspects of the use of technology in court.
Yes.
And how to obviously amend the way one presents one's case in a virtual environment.
Yeah. Look, in May of this year, the Supreme Court of Appeal put out a directive that they are going back to in-person hearings. There are some court proceedings that work well in virtual hearings, like opposed applications, reviews. But a trial doesn't really work. I've run cases virtually. So what are you doing? You're cross-examining a small face on a screen. If you are presenting before, say, 3 judges, you see 3 little faces there, and 2 of them look like they fell asleep. You can't connect virtually. It's impossible. We are people. We need to be in the presence of one another to communicate effectively. So I'm very pleased to say we're opening up, but we could have a spike in this virus. There could be another different pandemic, and a lot of the virtual type of work we do is here to stay. So I took the trouble of writing a chapter on how to present in a virtual hearing. And I started the chapter by not "you're on your feet," I wrote "you're on your seat." And now you're presenting to a judge. I tell you, speaking from my personal experience, when I'm sitting and talking and I want to be really persuasive, I'm not as effective as when I'm standing on my feet, okay? You noticed that when your wife yells at you, she's never seated, is she? Or when she wants to start an argument, never seated, they're on their feet. Okay, that's when you become persuasive. So I think the virtual platforms have a place, but I'll tell you what we did as well. I got one of my colleagues, she's here, Doris Goodenough, and she's a software expert on filing and retrieving information while you're on your feet in court, either in person or virtually. And she's written a chapter in the book. So it's quite useful, but I must tell you, there are lots of different software that can be used. Now, the pilot program that is happening, it's going to start in July, 22nd of July, I think it starts, when in Gauteng, we'll be filing electronically. You'll have to learn how to use that system. And I was a bit worried when I saw that the whole training manual was written by Sita. So now you have to worry. Let's hope they get it right. But if they don't, I think the legal profession is going to come out in protest. If you want to see lawyers toy-toying, you will see it then. because there's nothing more frustrating to set up your whole practice on a particular system over which you have no control and it doesn't work. So let's hope. I've no doubt that the Chief Justice wants this to work because it's the future. And I'm sure they'll get it right.
Excellent. So I know that you've done more than one title with LexisNexis. You've done several titles with LexisNexis.
Yes.
Do you want to give us a bit of an overview of the work that you've done so far?
Well, with LexisNexis, this is my third book. I wrote a book on drafting skills and a book I co-wrote with a solicitor from England, Terry Harrison, who's an expert on electronic discovery. We wrote a book called eDiscovery, a guide. That's available through LexisNexis. By the way, in this book, I present an entire case study on how to prove electronic documents in court. You're on your feet. How do you go about proving an electronically sourced document? How do you handle the metadata and so on? So those are the formal publications. I also wrote a book on case management for the Law Society. Unfortunately, that's out of print. It got sold out. I wonder why, but anyway, it got sold out. But being Law Society, they're taking a long time to do a second print on it. But I also wrote a lot of manuals, lots of manuals, short manuals for the Law Society, for Legal Aid SA, and for a number of institutions. But those are more focused on the requirements of the lawyers working in those institutions. The Law Society, of course, they provide the materials for the profession generally.
All right. So now I have to ask, obviously, you've done these titles over time, and this particular title, Trial Advocacy, why is now the time for this title?
Yeah, I think it's more a time that somebody did write something like this because we need it. What most people don't understand is that you win a case not because your witnesses were brilliant or your witnesses told the truth. Our system, which is an adversarial system, is such that the judge doesn't really know who's telling the truth. What a judge can do, though, the judge can listen to the version or the story and work out what is likely to have happened given the circumstances. Now, if a judge finds that a version is not likely to have happened, I'll give you a classic example, Oscar Pistorius's version. I mean, no one thought it was likely to have happened, so you disbelieve it. Now, what does an advocate do? It takes a skillful advocate to take a version and present it to a judge in such a way that the judge listens to it and says, of course, I think that is what happened. If you can't do that, your opponent will get the better of you. Or you lead a witness who's actually telling the truth. But the judge is not impressed. And the judge says, well, I wasn't impressed with Mr. Smith, and I reject his version. The poor man was telling the truth. Whose fault is it? It's the lawyers. They didn't do their preparation. They didn't prepare the witness properly. And they didn't lead the facts correctly. Simple thing like leading the story in a sequence. If you don't do that, it's all over the place and the judge doesn't know what's happening. But once you sequence it, it starts making sense. It now tells a story. So those are the kind of techniques you will get here.
Absolutely. And that sounds incredibly useful. Now, I know that you've been working with LexisNexis for a while. Do you want to describe and be kind, do you want to describe your overall relationship with LexisNexis as a partner?
Well, I was hoping you wouldn't say be kind. You should say be honest. Well, look, it's been very useful. I'll tell you what impressed me is that they're genuinely trying to come up with products. that meets the purpose that an attorney needs. Let's take a young attorney who's starting off in practice. They don't have the resources to invest in a huge library, nor do they have the resources to buy programs from various suppliers and find themselves confused by all of this, trying to access it online. What Lexis has done is that they put their products into a niche so that if an attorney requires something, they'll have it and they'll give him what he wants. Now, what they've done is that they've got a program called Practical Guidance. For instance, it helps an attorney through the entire procedural stages and shows the attorney what to do. Now, they've asked me and Advocate T over there to revise the whole product, and we are busy doing that. For instance, as lawyers, we have this habit of making a legal submission and then supporting it with a reference to cases. But then we'll give you 20 cases. Now, who reads 20 cases? Who's even interested in 20 cases? So what we've done with Lexis is that we trimmed out all of that. What a lawyer needs is one decision, the most recent one of the highest court. That's it. So don't waste the judge's time or the lawyer's time with 20 cases. Let's put our finger on the one case that you need. Now, that's the kind of thing we're doing. We've got some challenges. I sound like a politician. Challenges means there's a problem that with the way the IT works. I've had reports that it can be a bit frustrating to navigate. Well, we can fix that too. But generally, the product itself is quite brilliant. It's all a young attorney will need, and it doesn't cost much.
That's awesome, and spoken by the judge. So we have some interesting comments coming through here. Herman Stain says, thank you, LexisNexis and Mr. Hussain, for a very well presented and interesting presentation. I wish you success with your new publication, as I'm sure that it will fill a long-standing void. And then we have another comment here. I was and am very proud to have co-written the e-discovery guide for South Africa with my friend Ismail, and I wholly recommend his new and very valuable book. And that's from Terry Harrison. All right, and then let's talk a little bit more about your relationship with LexisNexis by bringing in content manager from LexisNexis, Sumantha Reddy. Firstly, what's it like working with Advocate Ismail?
It's interesting. Advocate Hussain is exceptionally smart man. He's exceptionally funny, and he's completely irreverent, which is a perfect score in my books. Yeah, it's been a long time, Ismail, 4, 5 years.
Yeah, thank you.
Yeah. So yeah, it's very interesting, and I think with Ismail, what's best to say is his passion and dedication to the legal profession is something to be admired. You don't get rich being an author, certainly not of a legal textbook. You do it because you have something to share. And I say to Ismail, what he's doing is he's leaving a legacy behind. And that's amazing. He really does believe, and he wants to help everybody, or the new professionals, to be the best that they can. So, I mean, along with the books, what Ismail and I did, and my passion within my role is basically to decode or to translate all that heavy legalese into texts that are more relatable to the profession today, or aspiring legal practitioners. And to that end, I think we focus on being practical, having very practical works, using plain language is very important. And I think, but to that end, it's important, and it's been the success for Ismail's book. And there's many reasons for that, and more so in South Africa, because
for many people, English is not their first language. And what we are trying to do with these practical guides is provide everybody with an equal opportunity of being the best practitioner that they can. So that's our role. And as Ismail was alluding to earlier, we're giving back, or we'd like to assist the legal market in that way. So it's very important to us.
Fantastic. Do you want to add to that?
Hold on, no, I have to say, I have to tell you this. It's a bit embarrassing. I told you this book is quite comprehensive. One of the things that happens to lawyers, I think it happens to all lawyers, before you step into a court, you do get the butterflies. You know, you get a bit nervous. I mean, I've been around for over 40 years and I can still get nervous. If someone tells me you're appearing in the Constitutional Court or the SCA, I'd have a few sleepless nights. And I wrote a chapter on it, on how you manage this nervousness. And the title I gave it was Performance Anxiety. Okay, so, and I sent the script to Samantha. So she rang me up and said, Ismail, performance anxiety. You mean in court? So, and then the penny dropped. I thought, oh my God. Looks like we're prescribing little blue pills. So we had to quickly change the title to Stage Fright. So if you look at the book, you will see Stage Fright. But what was there originally was performance anxiety.
I think that's a great comment. It really sums up the value that Samantha
you need somebody like her to read through it
has brought to this. That's excellent.
and come up with ideas.
Yeah.
I mean, I do the writing. I'm useless at everything else. But the designing, the formatting, the editing, there's a lot that goes into a book. Samantha actually designed that cover, which I thought was very good. And you know, I can't do that sort of stuff. So I just do the writing and I send it all off to her. And I really don't even worry about it because it just comes out so good. The Lexis has some first-class editors. I'm not sure where they found them, but the one that's worked on, this is my second book, Marjorie Guy. She's really very good. Is she back? She's in the UK at the moment. And, you know, I appreciate the work that they do. Now, if you read through the book, it's really user-friendly. It's good on the, easy on the eye and so on. I tell them that's what I want, but I'm not sure how to do it, but they do it. Okay.
All right.
If I may,
Go ahead.
I want to read a few excerpts from the book to give people an idea of just how relatable Ismail's content is. Like I said earlier, he is completely irreverent and he makes the law come alive. And I'd like to thank you for that, Ismail. Made me see the fun side of law. So just a few excerpts so you understand what this is all about. Okay, so this is part of being a good trial lawyer is to know how to deal with the unexpected. Trials, notwithstanding diligent preparation, can still be unpredictable. The most common problem crops up when a witness gives you an answer you were not expecting. It is as though the witness just dropped a bomb. What do? I can tell you that the judge will be looking at you, not at the witness. You have to be an actor. You know that the witness gave you the wrong answer. You have to pretend as if it was just what you wanted and move on effortlessly to the next question. Never show the judge or your opponent that you just got dropped. And this is just like following on from that. This is the presenting final argument. So I do like this chapter. It says, we come now to your final performance in the trial, your final argument. This is your last chance to pull your case together and persuade the judge to find in your favor. Presenting a persuasive argument is the ultimate skill. It is you and the judge. It is your skill that could determine the outcome. In my lengthy career, I have often come across seemingly hopeless cases being turned into victory in closing argument. Judges want to hear argument, but they want to hear argument that assists them. If you fail in this regard, you failed to persuade. Your task is to assist the judge to make the findings you want. So properly practical, and that's the benefit of this book. It's going to help everybody. Well done, Ismail. It's been a pleasure working with you over the years. I'm sure we have many more projects to go.
All right. I mean, that was just insightful, getting a taste of the actual book. And I think that's phenomenal. It really captures the character of the book. And I think it's going to make for good reading, whether you're a lawyer or not. In fact, there's someone who says something similar online, and that's Tepelo. This book will also help out people like me who have never practiced law before. We got another comment from someone who wishes to remain anonymous. I missed the reference made to the system by LexisNexis. All a young attorney will need. I think it's practical guidance, right?
Yes.
So please, can you assist me with the name? So just look out for practical guidance, or you could ask a question on the chat, and Pam will direct you to a website where you can get more information on that. All right, so let's just keep going a little bit more on the online stuff. Lots of questions, lots of stuff coming through. Let's go to Thomas's comment here. I did training with Nita on trial advocacy and how to tell a persuasive story. But it appears that this book, as gleaned from the book launch, introduces a new dimension to trial advocacy. So that's an interesting comment. And then just generally many positive comments. I'm not going to be able to go through all of it to talk. Motlebela says it's an insightful collaboration, thumbs up, good work. So generally quite a lot of stuff going on. Folks online, if you do have any further questions, please drop it into the Q&A box. On that note, what I would like to do at this point is I would like to be fair to our in-house guests, make sure that you get some time to interact as well. You will have the opportunity of networking directly with Advocate Ismail in person, over a glass of wine perhaps and some snacks. But for the moment, if you have a question that you would like to take up in this particular forum, you can now go ahead and do so. Is there anyone who would like to ask a question? There we go. We're going to have to do a bit of a split mic. So I'm going to have to pass my mic over to you. No, you're going to.
I could hear him.
No, my voice is louder.
Yeah.
We have to just account for the audience online.
Okay.
Thank you very much, Hussein. It was a brilliant presentation. I just want to know, how do I grab the attention back from a judge online in a matter where they've clearly lost interest?
Yeah, there's a whole chapter, the one on difficult judges, that very question is answered. The best advice I can give, if you are presenting in a virtual environment, whether it's an opposed application, an appeal, or a trial, what you must do is write good heads, not just good heads, excellent heads. You must, before you start, obviously, if you're in an opposed motion or an appeal, you would have written heads of argument. But let's say you're in a trial, you should have heads of argument. Now, when a judge asks a question, where it throws you off is when the question is not germane to the context. So it's irrelevant to the context that you are addressing at that time. You're making a specific point, the judge comes in and says, what about this? And it's unrelated to your point altogether. Now, one thing you don't do to a judge is say, thank you, my lord, that's a very good question and I'll deal with it later. You sound like Fikile Mbalula when you talk like that. So what you do is you answer it, okay? Now, if you've written good heads, it means you are well prepared. And that's the secret, because then you'll be able to answer the question, but answer it in a way that favors your case, not your opponent, okay? And it takes some doing, it needs preparation. You know, when I was a young advocate, when I was doing pupillage, no one gave us training in trial advocacy. Books like this never existed. Trial advocacy training started in around 1994, and that was the Johannesburg bar that did it. And I was one of their first trainers. We were trained by the bar itself here and by a group of QCs who came out from London to help us. And since then, it has developed quite well. But one thing is lacking about those courses. They don't really tell you what to do when the judge gets stuck into you. This book tells you.
Awesome. So Ava online says, I can't wait to read the chapter on dealing with the difficult judge.
Yeah.
All right. So let's take another question from the floor. Oh, we have a question.
Yeah.
Sorry. Thanks.
Ismail, have you been able to test your difficult judge on real judges?
Listen, I was a difficult judge, so I should know. Well, the technique I just explained has been tested and it works. It actually works. Oh, by the way, there's nothing in this book that hasn't been tested. What's in this book is 41 years of experience. That's what it is. You cannot either teach trial advocacy or write about it if you're not a veteran of many, many trials and court appearances. Okay. You know, it's like teaching someone to do something, but you've not done it yourself yet.
Absolutely. So basically, you're saying that you were the toughest judge that you've worked with.
No, I was not.
All right. Okay, folks. So, we have a raised hand here. I just want to also make a final request to anyone online. We will be taking your question shortly. Anyone online, if you do have a question, now's the time to place the question in the Q&A box so I can take it up. So if you could please queue that up in the meantime while we take this next question. Thanks, Dan.
Thank you. Ismail, how do you persuade a judge who clearly has made up his mind on a matter? Will I be able to find an answer on that book?
Yes, I'll tell you what happens. It's a myth that judges made up their mind long before the case ends. I'll tell you what happens with judges. You know, in the past, when I started at the bar, judges never read the file. They saw the file for the first time when they walked into court. And then it was your job to take the judge through the papers. It was tedious, time wasting. Now, judges are trained to read the papers before they come into court. So they would have read the record. If it's an appeal, they would have read the heads of argument, or they would have read the pleadings or 3 sets of affidavits. Now, get one thing straight. Judges are human beings. When they read your papers, they will walk into court with what we call a prima facie view. They have an idea of what they want to do with this case. They haven't heard any argument yet. They haven't heard a witness yet, but they have an idea. Now, if that prima facie view is in your favor, then you're smiling all the way, and your opponent's got the problem. But your question is really, what if it's not in your favor? Now, it might appear that the judge made up his or her mind already. When you sense that is happening, what you need to understand is that the judge is merely articulating the prima facie view. Now, you get 2 types of judges. Ones who actually walk into court and they'll tell you what the prima facie view is. That's fantastic. Now you know where you stand. You get other judges who just sit there. They'll write notes and you just don't know what they're thinking. But if a judge indicates and the prima facie view is against you, then you have to work and work hard to turn the judge towards your side of the story. And then you will see that the judge didn't actually make up his or her mind already. But if you're an advocate or an attorney who has not prepared well, and you cannot answer the judge where the question or the inquiry appears to be against you because you didn't prepare well, well, it's not the judge's fault. It's the practitioner's fault.
All right. So I hope that answers that question. Excellent. So we have two questions that have shown up online here. Let's try to roll them into one. One is from Chris. It says, how do you get a judge to read the papers? And the second point here is from Mpumi. Some judges are very rude and try to intimidate poor counsel. And how do you deal with such judges?
Yeah, that's the whole chapter in the book about difficult judges. I could talk about that for a long time, but read the book. But the first question, the first part.
How do you get a judge to read the
read the
papers?
papers? Now, look, judges are supposed to read the papers before they come into court. But we all know that not all of them do so. Now, under case management, there's something very important that has taken place. In the past, judges read the pleadings. They read particulars of claim and they read the plea, and they had no idea what was happening because it all came out of a precedent somewhere and didn't help the judge. So, but now we don't allow you to go to court with precedent-based nonsense. The parties are case managed into agreeing what the tribal issue is. So these days, if a matter has been case managed, the judge will know from reading the minutes of the case conference, or in Gauteng, they have a form which gets filled in, where the parties have to write down what the tribal issue is. They don't, without reference to the pleadings, in fact, you put the pleadings aside, just tell the judge in your own words what the tribal issue is. And that's the most important first step. The judge needs to know, what am I supposed to answer? What's the question? What's the issue? That's the whole purpose of reading. But let's assume it's an opposed motion. We got no guarantee the judge read 3 sets of affidavits. And I'll tell you what will help you to encourage judges to read is to write short papers. If you're going to write affidavits that run into 120 pages, if you write heads that go into 60 pages, they're not going to read it. And I can tell you, when my clerk used to walk in with a file this big, do you think I was encouraged to read that? Nobody is. Nobody does that. Nobody sees a huge file and says, oh, I'd like to read that. So keep it short. Keep the affidavit strictly relevant. Keep your heads short and to the point. These days, in the SCA, in the Constitutional Court, there are page limitations. You are told you have 50 pages or you have 40 pages. Okay. Now, we all know as lawyers, if you can't make your point in 40 pages, you're not going to do it in 120. But there are colleagues who will use 120 pages. Now, that's not persuasive. So don't make unnecessary work for the judge, and they will read your papers.
Fantastic, very clear, very pragmatic. And the thing I love about that answer, and Chris, I hope you've appreciated that as well. I'm sure you did. Is that I think the way you answer that question really captures the essence of what you've brought to bear, even in the book. Lots of pragmatism, very simple, very practical, and it's really about getting the job done, not running rings around for the sake of it. So that's fantastic. Is it safe to assume that there are no further questions on the floor? Oh, we have another question. Dan?
Thank you very much for the opportunity. I want to find out, what is your take on a situation where you are preparing for a trial, and then 2-3 days before trial, you receive an email from the judge's register saying, can please both parties furnish me with their heads of argument?
Yes.
So personally, I've got some difficulties with that because no evidence has been laid yet. So what exactly are we going to say in those heads? Normally, if I'm given an option, I always decline that to say I'll finish my heads. After the trial and hand in hand with my closing argument, I will present my, what's your take on that way?
Okay. Now, if it's a trial, look, if it is if it is opposed motions, a review, an appeal, or anything in the Constitutional Court, you are compelled to file heads before you get a date. But let's take a trial. There is no rule that requires you to file heads of argument in a trial. And it is very unlikely, I've not come across it, where a judge will want you to, will tell you to file heads before any evidence has been led. What you may be mistaking this for what some judges will do, and there's nothing wrong with it, where they will get their registrars to inform the parties that the judge will be expecting heads of argument. What that means is, once the evidence is finished, then the judge will allow you time to write heads. They'll adjourn early or they'll give you a day, and then you are expected to file heads of argument. Now, the best technique is to start writing your heads before you issued the summons, okay? Because that then gives you the script of how to run your case, and at the point when you get to your final argument, some of the disputes may have been resolved and there may be only one issue left. So all you have to do, or the performance of your witnesses didn't work out as you had anticipated. So what you do then is you merely amend your heads. It shouldn't take you more than a couple of hours and you're good to go. The mistake that is made by lawyers is that they wait until it's time to argue and then they want to go and write heads of argument. That takes time, it's stressful, and besides, you were not well prepared. It's as simple as that. I can assure you, there is nothing better than writing heads of argument to prepare you for a trial or for any hearing, because that's when you're writing, you're applying your mind, and that's what gets you thinking. The writing is what stimulates thinking. If you're copying and pasting, you're not thinking. You're not a lawyer in the first place. You become a lawyer when you start writing the points in your own words, not copying from a judgment or a textbook. And that's the best way to prepare. And you'll never have a problem in court.
Excellent. So I got a few comments coming through online. So I think what we'll do is let's just wrap it up.
Yeah.
This is how we're going to do it. If you have like maybe a quick comment for some of the things coming through, we'll just go through it very quickly. Mpumi has a funny comment here. He says, we get paid by number of pages we type at times. Perhaps we should be forgiven for writing lengthy pages. Yeah, Mpumi, that was not said into the microphone. If you didn't hear that, it is unforgivable. All right. So another comment here online. Is it possible to bypass pupillage just by reading this book? In other words, can I be able to be a successful lawyer just by reading this book without necessarily fulfilling pupillage obligations?
No. It has to fulfill pupillage is professional vocational training. And it is a legislated requirement. You cannot duck out of it. The person who asked that question, I know where they're heading, what they're getting at. They're getting at the enormous difficulties people have in securing pupillage and securing pupillage with the right person. That's really a serious problem in the profession, that it is essential to do vocational training. Attorneys have to do it as well.
Yeah.
Doctors have to do it, accountants have to do it, engineers do it. Why not us? Look, of course, we're a profession that knows everything, but you need the professional, the vocational training.
Yeah, absolutely. So definitely this book is many things, but definitely not a replacement for pupillage. All right, Tapelo asks, what do you do when you don't want to answer the judge's irrelevant question to the point that you are making?
Yeah. Now, judges often ask questions that are not relevant to the point you are making. And when a judge does that, it's because the judge is concerned about something. There's something troubling the judge. It's a bad advocate or attorney who doesn't satisfy the judge and then move on. Okay. Now, if you think as a lawyer that the judge is being irrelevant, don't tell the judge that. You tell the judge that's a brilliant question and you will answer it.
All right. So Tafelo, I hope that answers that very loudly and clearly. I have another one here. When doing, it's a little bit poorly worded, so I'm going to do my best to get the question across to you here. I am not sure that I'm going to pull this one off. So I tell you what, we're going to bypass this question. It does come from anonymous, so unfortunately I can't apologize. But let's do this. Any other questions here on the floor? No further questions. See, us non-lawyers might find that funny, you know, because we watch TV. All right. So on that note, as a non-lawyer, I think I've learned a ton. I think you have a very enjoyable style of communicating. And if your book is anything like you sound, just verbalizing some of the points, I think it's going to make a splendid read. It's going to be incredibly useful for someone who really wants pragmatic, practical skills, something they can do on the job to be very successful. And I really think, honestly, just as someone who's very interested in academia as a whole, I think this is the kind of learning and education that South Africa really needs. You know, the kind of stuff that's very practical. Just get out there and get the job done well. You know, cut the fluff out. And I think we just need to support more and more attempts at education of this nature, this particular variety. So just a real pleasure to have met you tonight, to have had this kind of discussion. I'm scripted here to thank you, but I want you to know that even if they didn't tell me to thank you, I'm deeply grateful for what you've shared this evening. To all the attendees here, thank you so much for leaving your warm homes. For those of you who weren't being load shed tonight, thank you for leaving your warm homes and for joining us in person. I think what a great opportunity for us to just break from this mundane method of doing seminars and webinars that we've had to endure for the last few years. So for those of you who've decided to come in person, thank you, a special thank you to you. In fact, we are so grateful for your in-person participation that we've even provided wine and catering. And I'm told by the caterers themselves that the catering is exquisite. All right. And then, of course, we've covered several questions. If you still have questions and if you are online, please connect with Pam. Pam is managing the chat. She has placed her details in the chat for you. Pam, you can go ahead and share that again if you'd like. Equally, we've put some links into the chat. For those of you who want to take further action, maybe get yourselves a copy of the book. We've put the links into the chat. It's been running for a while. And for those of you who are in person, please find a phone and click the link on your phone. That's just a joke. I don't actually even know how they would get a copy if they are in the room, but we can figure something out afterwards. You guys can just hound Samantha, all right? And on that note, we can consider this the official end of our session. Thank you once again for all of the wonderful ideas that you've shared. And I look forward to a networking evening now where you have the opportunity to interact not just with each other, but also with Advocate Ismail. So with that, thank you so much.
So I said quietly.